Now let's meet our panel and our moderator. I am so delighted to introduce you to Sherman Smith, who will serve as our moderator. Sherman is a Kansas native and award-winning journalist who joins us from the Kansas Reflector. He's written thought-provoking articles on the Kansas legislature, as well as government misconduct, the failures of our Kansas foster care system, education, and many other topics. In 2021 and 2022, he received the Kansas Press Association Journalist of the Year Award. Last year, in 2021, Sherman served as a panelist to our legislative recap, and he joins us here as our moderator. We now turn to Sherman, who will introduce our panelists. Sherman, thank you very much.
Thank you, Connie. Thank you for having me and the panelists here. Thank you to everybody who's tuning in to watch this discussion. So we have a lot to talk about today, so I'm going to introduce everyone to our panelists, and then we will dive right into this. Dr. Micah Kubik returned as the Executive Director for the ACLU of Kansas in January of 2022, having served in the same capacity from 2015 to 2018. From 2019 to 2022, Micah served as the Executive Director of the ACLU of Florida, one of the nation's largest ACLU affiliates. He has more than 20 years of experience in civil rights and racial justice work. In 2016, Micah's first book, Freedom Incorporated and Black Political Empowerment, was published by the University of Missouri Press. Welcome, Micah. Next, we have Judge Patrick McAnany, retired from the Kansas Court of Appeals in January 2019, culminating a 17-year career serving with the Court of Appeals. However, Judge McAnany continues to serve as a senior judge of the Kansas Court of Appeals under contract with the Kansas Supreme Court. Prior to his appointment, he served 10 years on the Johnson County District Court beginning in 1995. He had a 27-year career in civil and business litigation. Currently, Judge McAnany chairs the Judicial Ethics Advisory Panel, an appointment from the Kansas Supreme Court. Welcome, Judge. Finally, we have Amy Castle. In 2016, Amy Castle joined the faculty at KU, where she teaches at the Law and Business Schools. Amy also teaches constitutional law through KU's Political Science Department. Before teaching, Amy practiced law in downtown Kansas City for 2 decades. Amy has been an ACLU of Kansas board member for 5 years. Welcome, Amy. So, as Connie went through, we have a number of extracurricular activities on the ballot this year, in addition to all of the usual legislative races, congressional races, State Board of Education. We're going to start by talking about the 2 constitutional amendments, and then we'll talk about the judicial retention votes. And we're going to start with what's called the Proposed Legislative Veto or Suspension of Executive Agency Regulations Amendment, because I guess it would have been too easy to just call it we don't want the governor to act independently, we're going to tell her what to do amendment. So let's start with Amy. What are we really talking about here? What is the intent of this amendment?
Well, I'm not going to so much go into the intent because I think I can't, I don't know what some of the legislators were thinking, but I have an idea. And essentially what we're talking about with this amendment is taking away power from executive agencies, which are part of the executive branch, right? We have these administrative agencies. So the legislature makes the laws, and these administrative agencies enact rules and regulations to enforce those laws, right? That's the executive branch's power, is to enforce the laws. And so what we're actually talking about here, if an executive agency, let's say the Department of Health and Environment, right, creates a regulation or a rule, maybe creates a regulation that, big companies can't dump toxic materials or toxic chemicals into our creeks and our rivers and our streams. So what this would do, if that executive agency passes a regulation, can't dump toxic chemicals in our lakes, currently, if the legislature doesn't like that regulation, they have to pass a law, just like any other action that the legislature has to do, right? And so what that would require is the legislature has to get, a simple majority of legislators to enact a law to revoke that regulation. And then, though, it goes like any other law to the governor, and the governor can veto that law. And then if the governor vetoes the law, it goes back down to the legislature, and it will require a 2/3 majority or veto-proof majority to revoke that regulation. This amendment, if passed, would take the governor completely out of the equation. And so that if 51% of our legislature decides that they want to revoke that regulation, they can do it with a simple majority, 51%, and it never goes to the governor. There's no veto power. So it's basically taking power from the executive branch, those administrative agencies that the governor oversees, taking power from the executive branch and giving it to 51% of our state legislators.
Thank you. So, Micah, the legislature, they already have this ability to pass a law to override the governor if they have a 2/3 support. As Amy mentioned, they could now do this if the amendment passes with a simple majority. They could say, we don't like what the Department of Labor or the Health Department or anybody else is doing, and we're going to tell them what they can or can't do. What do you see as kind of like the practical effect of how this is going to play out?
Well, thank you, Sherman. Good morning, everyone. A pleasure to be with you this morning. Happy to see some names I know in the participant list there. So, and of course, happy to be with my friend Amy Castle this morning, who I adore. So, I think we should just be honest about what the intent of this particular amendment is. This is not about good government. This is not about efficiency. This is not about making the wheels of the machinery of government move more smoothly. This is just quite simply that there are some folks in the legislature who don't like what the current governor has done. Right? It has nothing at all even to do with what any other governor in history has done. It is instead an immediate reaction to specific policies that they disfavor with the current governor. And rather than accepting the Constitution as it is, and rather than accepting the system, and rather than accepting that we have a separation of powers in the state, and rather than accepting that sometimes the voters express their will in different ways and expect different things from different branches of government, some folks in the legislature have decided to move this forward instead as an attempt to stop the governor from doing things that they don't like. And I think I am particularly concerned. Amy already listed some of the ways that this could play out. I think what I am particularly concerned about, and what I hope that this group is particularly concerned about, is that the governor does have some authority over voting rights. The governor and executive branch agencies have the ability to implement several things related to voting rights. And given the hostility that we have seen from this legislature and the one before, it is not crazy pants to believe that the legislature would try and dial back anything that the governor tried to do to defend voting rights and to defend democracy. We saw that already in this year's legislature when they passed a bill to restrict the governor's ability to enter into consent decrees and to settlement agreements under the National Voter Registration Act. The governor is just doing what she is really required to do by federal law. And the legislature found that so horrific, found the idea of implementing federal law on voting rights so abominable that they did pass a law to stop her from doing that. I think you will see exactly that same sort of thing play out over and over again anytime that the legislature and the governor come into conflict with one another. And again, I don't think that's just about the governor that we have now or the legislature that we have now. What this really does is set up a permanent state of conflict and chaos between the governor, whoever they are, and their ability to implement laws, and the legislature, in perpetuity. And I think that is really a sign of instability, and it creates uncertainty in the state government in a way that I think is really, really dangerous for democracy.
Yeah, as you say, there's a wide range of conflict that we've already seen from some of these rules, from contact tracing at the health department during the pandemic to kind of part of the catalyst for this was dealing with the labor department and kind of their rules for workers' compensation. But you mentioned the separation of powers issue, and so I'll throw this question to the judge: is there a constitutional question with this amendment and the separation of powers between the executive branch and the legislative branch? You know, how would that argument play out? Not asking you to weigh in on you know how that would be decided, but just kind of the mechanics of a legal challenge to this. What would the considerations be?
Well, we do. Our Supreme Court calls for a separation of powers between the three branches of government. That's how the system works. That's how the system of checks and balances work. As between the legislature and the governor, that would be a confrontation between the executive branch and the legislative branch, and they each have their separate roles, and one is not to encroach upon the other. And if you could probably expect that there would be some sort of a challenge if this were enacted, in which there would be an effort on behalf of the executive branch to challenge the authority of the legislature to come in and take control over the executive agencies that the governor has traditionally and arguably under the Constitution is entitled to control and appoint and regulate. And I'm sure Amy probably has something more to say about that too.
I do, Judge McAnany. Yeah, so I think if this amendment passes, there absolutely will be a legal challenge, and probably a pretty solid legal challenge, because in 1984, our Kansas Supreme Court decided a very similar case. It's Stefan versus Kansas House of Representatives. And it was a very similar case where the legislature was trying to take power from the executive branch and revoke agency rules by a simple majority. And the Kansas Supreme Court back in 1984 said that is unconstitutional. That violates separation of powers. And so our Kansas Constitution, while it doesn't actually say the three branches should have separate but co-equal powers, it's implicit, right? And that's what the court said. Even though it doesn't spell it out in the Kansas Constitution, we have this notion that the power should be divided among the three branches, and specifically held that the legislature, in attempting to revoke administrative agency rules by a simple majority, violates separation of powers. And to my knowledge, our Kansas Constitution has not changed with respect to separation of powers. So I would expect absolutely that if this amendment passes, as soon as the legislature tries to revoke an agency rule or suspend it, that there would be a legal challenge, and potentially a successful legal challenge.
So, Amy, if this passes, and setting that legal challenge aside, if the public says we made a terrible mistake, we created this mess, how do we fix this? Is it possible to undo a constitutional amendment? How would this be resolved?
Well, I think the only way to undo a constitutional amendment is a new constitutional amendment, undoing it. That's the only way that I know of. Maybe there are smarter folks who know of a different mechanism, but that's the only way that I know of. If we amend our Constitution, the only way to then amend our Constitution is to amend our Constitution again. So it would take then the legislature putting forth a constitutional amendment, reversing course, and I don't really see that with our current legislature.
Right. The last question on this, we'll come back to Micah, because we've talked about, you know, all these different rules and regulations and the agencies out there. What do we think about the legislature wading into these decisions? Legislature being a political body primarily, and we have, some people at the agencies who, spent their entire careers digging into the very specific details of some of these processes and how things get done, and that could be evaporated overnight if the legislature doesn't like it. Is this good public policy, Micah?
I think you already set the answer up for that, Sherman. Ryan said the answer is no, of course it's not good, right? Of course it's not. We expect different people in government to play different roles. And we absolutely expect that civil servants and that folks in the executive branch agencies have expertise, have devoted their lives to this. They go through a very robust process in the first place. It's not as though they just cook this up overnight and then out it goes as a rule and regulation. The only folks who cook something up overnight and then make it into law are the folks in the legislature, where we oftentimes see them passing things that they have not even drafted yet. They pass a conceptual bill without having even written what the text of it is and do it in an hour span. That's not the way the executive branch agencies work. They go through a robust public comment period. They gather data. They compare it to what other states are doing. I mean, it takes a really long time because they are really quite thorough about it. Doesn't mean that I always agree with the rules and regulations that come out of the state agencies either, but it is certainly the case that they are thoughtful and deliberate in the process they go about it, and we should respect that. And where there are opportunities to challenge it, we should do so, but we should do it again through a thoughtful and deliberate process, not on a wild political whim that someone has overnight, which is really the process that this particular amendment would set up. And I just want to note to Amy's point, too, that the thing folks should remember about constitutional amendments in Kansas is that the process is completely controlled by the state legislature. They are the only ones who can propose them. It is not like our neighbors to the east in Missouri, where the people themselves have the power to propose constitutional amendments. We have the power as voters to tell the legislature to go jump in a lake when they send us one we don't like, as we did on August 2nd. But the fact that the legislature itself also controls the entire constitutional amendment process and now wants to control the executive branch agencies and the sort of technical expertise and statutory authority all at the same time, I think is a really dangerous recipe.
So I think of this as the we're going to tell the governor what to do amendments. We're going to move on now to the Second Amendment, which is, I like to think of it as the Protect Calvin Hayden Amendment. It's called Proposed Kansas County Sheriff Election and Recall Amendment. But this was talked about in the legislature as a reaction to some discussion involving the Johnson County Sheriff, Calvin Hayden. Even before this year, I think had landed on the radar of some people in Johnson County who started talking about, if we ever wanted to change either the way that the sheriff is elected to maybe an appointed position, or if they wanted to think about how to remove a sheriff from office, how would they do that? The legislature responded by putting this amendment on the ballot. So this has gotten a little more attention, I think, because of the sheriff's actions lately. But taking a step back here, Judge, can you just walk us through what this amendment is, what it would do, what it's about?
Tell you, Sherman, I'm going to defer to Amy on this one.
Okay.
If I can, please.
Sure.
I'm happy to take this one. Thank you, Judge. So there's two parts to this amendment, the election of sheriffs and the removal of sheriffs. So let's take the election of sheriffs. So what this amendment would require going forward is that sheriffs, every county must have an elected sheriff, an elected official as their highest law enforcement person. And so right now, currently, we have 105 counties in Kansas. 104 already elect their sheriff. The one exception is Riley County. Riley County consolidated their county and city government back in 1974. So they're exempted from this amendment. So we're really talking about requiring the counties to go forward to always elect their sheriff. And so, and where this might come up, why do we need an amendment if we're already pretty much doing this? Well, under Kansas law, a county and a city government can consolidate. And if a county and a city government consolidate, right, be more efficient, what Kansas law says that, okay, if you have a consolidation, then you're going to create a board, people who are going to appoint a police, the head of police. So the head law enforcement person, right, would be appointed by bureaucrats rather than elected by the people. So that's one thing. And I know Judge McAnany has some thoughts on whether that's good or bad. But really, where I see the problem with this amendment is in the second part of it, the removal of sheriffs. So currently, our current law says that if a district attorney or the attorney general believes that a sheriff has engaged in some sort of misconduct, right? You know, tampering with evidence in a criminal case, or, you know, doing something with the finances. If a district attorney or the attorney general believe that a sheriff is engaged in misconduct, then either the district attorney or the attorney general can initiate a legal proceeding, file a proceeding, a quo warranto proceeding, horrible word. But basically what that does is says, hey, court, we think a sheriff's behaving badly. Can you look into this? Ultimately, a judge would decide whether a sheriff has engaged in misconduct such that they should be removed from office. So it's a judge who decides ultimately whether to remove a sheriff, but it's either a district attorney or the attorney general who can initiate that proceeding. What this amendment would do would take away the power from all 104 district attorneys to initiate a proceeding, to investigate a sheriff, and rest that power solely with the attorney general. And so where I see the problem in this is that, you know, think of, you know, the rural counties where it might be the district attorney, the only person who works day to day with the sheriff's office, right? It might be the district attorney who discovers sheriff shenanigans, right? And if this amendment passes, what happens is the district attorney then has no power to initiate an investigation. So the district attorney, right, calls the attorney general, depending on who's in office, right, and says, hey, will you start a legal proceeding? And the attorney general can say, nah, we good. I kind of like the sheriff, right? And so it puts the power with the person who sits in Topeka for most days, right, with the only person who has power to initiate an investigation into a sheriff will be solely with the attorney general, and it will take away power from our local district attorneys to even initiate an investigation into a sheriff. So that's where I actually see the problematic piece of this amendment is the removal of sheriffs. And mind you, so the amendment, while it would take away power from the district attorneys, all 104, it does not change the power of the people to recall a sheriff. So, and I kind of want to clarify, because in the original slide, it said that we have the power if we have 40% of votes from the last sheriff's election. Well, what happens with a recall election, if I'm a voter and I'm not happy with my sheriff, if I go out and I get 40% of my friends to sign a petition, 40% who voted in the last election, I present that petition to my county election clerk, and then it goes on the ballot. And then if 51% of folks believe that the sheriff should be removed, then that sheriff will be removed. So the amendment doesn't do anything with respect to recall by voters. That process would remain the same, but it would take the power away from local district attorneys.
So we'll break this into these two parts, and we'll start with the first part of this, which is requiring elections for sheriff. Doesn't actually change anything as far as how all 105 counties are operating now, but it makes it so that they never could change. And so this is defended, I think, is sort of an appeal to democracy. The top law enforcement official in a county is an important position, should be held accountable by a popular vote. Judge Jamie tells us you have some thoughts about this. Do you want to weigh in?
Well, I'll just comment that we have the ability now to consolidate city and county governments, or the government in the county, Riley County has done that. Kansas City, Kansas did a shorthand version of that with the unification of the government of the county and the city, but wasn't countywide because Edwardsville and Bonner Springs are not part of the unified government. But in all other respects, they've unified the government and eliminated duplications in services and positions, and tried to be more efficient. And I think that's the goal of government, to be as efficient as possible. And I think this amendment eliminates the possibility of, well, you still have to have a chief law enforcement officer in the county, but there's no reason, it seems to me, other than, as Amy has described, that needs to be an elected position. I'm old enough to recall in our county, going all the way back to Margaret Jordan, who was a district attorney, Dennis Moore, who was a district attorney here, Paul Morrison, and then our current district attorney. And quite frankly, I have never seen any functional difference in terms of law enforcement. That is, I don't believe that based upon a party affiliation, one is more efficient in fighting crime in our community anyway. I would hate to see that communities like Johnson County, for one, foreclose from the possibility of we'll never have a unified government because we have too many municipalities in this community that are not going to be willing to give up their authority. I can guarantee you that. Some very small communities that they're very proud of their own locality, and they're not going to do that. But the fact is that I see no reason why we should foreclose that possibility for other communities.
So, Micah, let's talk about the second part of this amendment, because I imagine the ACLU would have some heartburn here about, what happens if there's a sheriff running around threatening civil rights in Kansas, and what avenues you have to address that. Are you concerned about this amendment?
So I don't think that we need to talk about that as a future, speculative thing. I think that is in fact the state of play that we have now, particularly with the Johnson County sheriff, who, especially in his supposed investigation of voting rights, has certainly engaged in some behavior that is really, really frightening, and in some of his proposals or elections should be run. I mean, folks may remember he proposed not too long ago, tried to pressure the elections commissioner into having his deputies staff the election, right? So this is not a speculative thing, and certainly Johnson County isn't the only place in the state where we have seen sheriffs engage in behavior that is problematic, in some cases illegal, in some cases unconstitutional. So that's not we don't have to scaremonger about it as something that could happen. It is in fact something that is happening as we speak. That said, I mean, I do think there are real concerns about this amendment. I think some of them go back to what you said at the beginning, Sherman, which is this is not an idea that was just sort of long germinating and folks suddenly decided, oh, I guess this is the year where we finally need to do it. It is instead a direct reaction to folks being concerned about the behavior of one particular sheriff, and then an entire amendment being architectured around how to protect that particular sheriff. One can love the sheriff, one can hate him. That doesn't matter to me, frankly, in this particular context, but we should be honest about the fact that the amendment exists because there are some folks who want to protect the political interests of this particular sheriff. And to your sort of point about democracy before, too, Sherman, I think the important thing to remember here is the same folks who insist that the sheriff must be elected in order to protect democracy, I don't hear them saying that police chiefs should be elected. You never hear anyone say that a municipal police chief needs to be elected as the chief law enforcement official in a particular city. Unless you are willing to argue that those two things are both necessary for democracy, I dare say that I find a little bit of hypocrisy in insisting that a sheriff must be elected in order for democracy to be defended. And I think the same goes for this sort of district attorney AG thing. You cannot say that you believe in local control, which is what so many of the folks who are behind this amendment say at every opportunity, and at the very same moment, in the very same breath, take away the ability of local county attorneys, district attorneys to do something about these sorts of situations. That said, as a committed civil libertarian and someone who is therefore deeply skeptical of government power at really almost every opportunity, I do think that we should be clear that there are opportunities for mischief regardless of who the investigatory authority here is, right? There are certainly examples where local district attorneys, county attorneys are deeply embedded and enmeshed with local law enforcement and with the sheriff's department, and so may be unwilling to investigate their friend, their partner at the local level, and where you do in fact need the attorney general or someone else to be that external party. And similarly, it is entirely possible that the attorney general sitting in Topeka has no interest, no knowledge, or their own political interests involved in protecting a sheriff. So I do think we should just be cognizant of the fact that there is opportunity for mischief and negligence in both of those instances, which is why you should have both avenues available to you to try and correct for any lacking in either one of them, and why keeping the recall function is so vitally important if you are to have a locally elected sheriff.
Sherman, if I can, I'd just like to jump in. So I've talked to a couple of the district attorneys about this, and so and all with whom I've spoken tell me that if they believe that a sheriff is doing something wrong, right? They probably themselves, their office, their district attorney office, probably actually wouldn't do the investigation. They would ask another district attorney from another county. So, but the point is that in this situation, if this amendment passes, they can't even ask their neighboring county to investigate. Again, the power rests solely with the attorney general. And Micah, you raised great points that no matter what, there can be misconduct and things that go wrong. But it seems to me that completely taking the power from these district attorneys to, investigate, start an investigation is problematic.
I mentioned the district attorneys because, as far as I'm concerned, that's where the real law enforcement stands, particularly in a county like Johnson County, which I think this amendment is really directed at. Understand that the sheriff, really his authority is over the unincorporated portions of the county when it comes to criminal law enforcement. That's not much left in Johnson County, let's face it, except for a few rural areas, which don't seem to be the hotbeds of crime. Most of the action is in our cities, as Mike has pointed out. Every city has its police chief that's appointed by the governing body of the city or elected, however they choose to do it. But the point is, where the rubber meets the road is in the district attorney's office, and not the sheriff's office, quite frankly.
I think we can continue talking about this for a long time, but we'll move on now to make sure we get some discussion about the retention of judges. Amy or Judge, if you want to address this, how does the system work right now? Why are we having these names on our ballot?
Well, we're having the names on the ballot because of our nonpartisan merit selection system that we use in Kansas for the selection of judges. And we'll talk about that more in detail. But first, I think we have to understand where these judges come from and what their functions are and how our courts system work in Kansas and more particularly in Johnson County. just as a general overview, you can view our court system statewide as sort of a pyramid, and at the base of the pyramid are our municipal courts, which are really not involved in the nonpartisan selection process. Every city has its own municipal court, and its job is to enforce municipal ordinances. You get a speeding ticket in the city, you're going to go to the municipal court to deal with it. The judges there are not selected usually by election, and they're certainly not by the nonpartisan selection process that we have here in Johnson County. They're hired by the city government, and they decide those kind of issues. And if they're when they decide a matter, there is an appeal process which would take a case to the district court for a completely new trial on whatever the issue is. That takes us to the district court, which is the second level of this pyramid, and it is probably for most citizens, for all of us really, it's where the rubber meets the road, and the most there are the most decisions that affect daily lives of us here in Johnson County. It's a court of general jurisdiction, the only court of general jurisdiction, meaning it's the only court that can hear virtually every matter that could possibly come before the court. They hear civil cases, criminal cases, juvenile cases, handle guardianships, wills that are being probated, you name it, it can be heard and is routinely heard in the district court. And we have a number of district judges who are up for retention. We'll talk about them in a minute. If you're unsatisfied there, you can appeal to the Kansas Court of Appeals, which is the third level of this pyramid. Kansas Court of Appeals is unique. It was created in 1895 simply as a temporary measure to deal with the heavy caseload of the Kansas Supreme Court at the time. But that statute expired. That was in 1901, and so the Court of Appeals basically went away until it was revived in 1977. And since then, we've had a Court of Appeals that now has 14 members, 14 judges, that hears appeals from the district court on all kinds of, virtually every kind of case, and reviews those and decides whether there was some error in what happened in the district court that would require the case to be reversed or sent back for a new trial. The majority of the cases are actually affirmed, but there are cases that are required to be reversed. The court sits in the Court of Appeals in 3 judge panels, and it's a traveling court. They travel around the state. I say we travel around the state to hear cases on a routine basis, and that gives the public an opportunity to see their court system in operation, particularly in some of the rural areas where they don't really have access to the Court of Appeals or any of the appellate courts on a routine basis. Just all appellate courts, you should know, are simply hear cases based on what the written record is that happened below. We do not retry the cases. We simply review the record to find out whether or not there was some error committed. The top of the pyramid is the Kansas Supreme Court. It hears important cases. Capital murder cases go there. Cases where a state constitution provision has been, a state statute's been declared unconstitutional. And they hear cases that come up from the Court of Appeals where there's a further appeal, and the Supreme Court has decided to take the matter. There are 7 justices on the Court of Appeals, and 6 of them are up for retention. We'll talk about them in a moment. And the Kansas Supreme Court is the final say on matters of the Kansas Constitution. When it comes to the United States Constitution, if they make a decision based upon that, an aggrieved party can seek review further on up to the U.S. Supreme Court, which the court may or may not grant. and in virtually all cases does not grant, but in a few cases they have. And so the U.S. Supreme Court is the final resort when it comes to matters involving the United States Constitution. That's the overall plan. I can talk.
The governor appoints judges at these different levels, and there's some details about how that happens, and in some cases the Senate can provide oversight, sometimes they don't. But the break on the system is this public vote, which is, I think, different from your other races on the ballot, because it's just a straight up yes or no for the judge. Amy, do you have additional thoughts on how this process works and what we're doing here?
So I'll, excuse me, I'll expand on Judge McAnany. So the Kansas Supreme Court, when there's a vacancy, the governor has the power to appoint a replacement justice. And that process for the Kansas Supreme Court is that you have this commission of attorneys and non-attorneys who, when there's a vacancy, anybody who's interested in becoming a judge, a justice, they apply. And Judge McAnany can attest to this. It's a very, very long application, pages and pages and pages. They're investigated by the KBI. And then what happens is the commission gives, and that's 9 people, attorneys and non-attorneys, gives the governor 3 names, and the governor picks which justice. So that's how that goes. The Kansas Court of Appeals is a little bit different because Governor Brownback changed it a few years back, such that there is no commission now with respect to Kansas Court of Appeals. It is like the federal system. The governor chooses a person, and then the Senate asks questions and then decides whether to confirm or not. So it's a little bit different, but in both instances, the reason why these judges are going to be on your ballot is because the very next general election, after a judge is appointed or a justice is appointed, they're up for retention, right? So it's the voters who say, shall we retain or not? A yes vote retains, a no vote kicks them out, right? And so, and then thereafter, every 6 years, a Kansas Supreme Court justice, Court of Appeals judge is up for retention. So that's why you're going to see there are 6 of the 7 Kansas Supreme Court justices up for retention, and 7 of the 14 Kansas Court of Appeals judges who are up for retention. So, and varying, some are, it's their first retention election after being appointed, some it's their 6th year, but there's going to be at least, that's not even counting district judges who might be on your ballot, but you know, doing the math, there will be 13 judges up for retention and that's the reason. By law, we get to say, you know, they're doing a good job or they're not doing a good job.
Thank you. If anybody listening is really excited about learning about the judicial selection process, you can Google something called the triple play. But I'd like to talk to Micah about the politics of this, because the courts are supposed to be separate from politics, but there's a very specific reason why these votes are getting a lot of attention now, and it has to do with the amendment that we saw in August on the constitutional right to abortion. The Kansas Supreme Court in 2019 determined that the Bill of Rights in the Kansas Constitution does guarantee, because of the right to bodily autonomy, the ability to terminate a pregnancy in Kansas. That was a 6-1 vote, and of the 6 justices that are on the ballot now, it was the 5 of the 6 who were in favor and the 1 who was opposed. And so with the amendment failing in August, there's now an effort from those who are opposed to abortion in Kansas to say, you know, if they could win the governor's seat and they could get rid of all of these judges, they could have a dramatic overhaul of the Supreme Court. Micah, what do we think about the, you know, politics entering this sphere, and the idea that any one issue could end up having a dramatic impact on the overhaul of the court? Looks like you're muted.
So I think it's really unfortunate, and I think that I think judicial retention elections are the worst possible judicial selection process, except for all of the others. I mean, I think there is frankly no great way to select and retain judges, but I think this is probably the best of the options. And I say that because I think the process has worked very well in Kansas for a long time, and folks have historically recognized that there are going to be some court decisions they agree with, some court decisions they disagree with, but that so long as judges are doing their job and are trying to respect the law and making difficult decisions, that is what we expect them to do. We do not expect to be happy and satisfied and completely at peace with the world every moment of every day. I think over the last decade, however, there has been a change there. So we should keep in mind that this is not the first time that there has been a concerted effort to unseat some of the Supreme Court justices. The last time it happened was 2016, when again, it was motivated purely by a disagreement over a particular set of decisions that the court made, in that case about school funding. So folks may remember the Supreme Court of Kansas ruled against the Brownback administration on some school funding issues, and were promptly met by a multi-million-dollar effort to get them to find new jobs. I think all of that, right, is a sign that is not the way the system is supposed to work. If we have confidence that the court is being impartial, is ruling on the basis of the law and the Constitution, then that's what we should focus on rather than individual decisions that they make. I think you have to see the effort to unseat some of the justices in concert with the two amendments that you're seeing in November, as well as the amendment that you saw in August, and that all of them are attempts to centralize power, to stifle dissent, to stop folks from expressing their views in legitimate ways, and instead to make it so that one particular point of view prevails no matter what other institutional barriers may exist against it, no matter what the people of the state themselves may say. All of these are efforts, they are one and the same, assaults on democracy and on democratic institutions. And to look at them independently of one another is to miss the big story and to miss what is really going on here. The other thing I'll say is, for the people on this Zoom this morning, your charge, your job, I'm giving you a job. Your job is to make sure that your friends and your neighbors know that the Kansas Supreme Court is not the United States Supreme Court. I cannot tell you how many folks I run into who don't actually realize that these are two separate institutions, that they are not one and the same, that actually Sam Alito and Ketanji Brown Jackson are not sitting in Topeka right now. They are in Washington, D.C. instead. These are two separate institutions. And so if your friends and neighbors are ticked off at the United States Supreme Court right now, as they have every right to be for the judicial hooliganry that we have seen there, make sure they know that that is not the Kansas Supreme Court. If you're going to be ticked off at somebody, be ticked off at the right person, and then make your decision about what to do on retention on that basis.
This has been a great discussion, but I need to turn it over to the Q&A portion of our event today so that we can get some questions answered from the public. While we're on this topic, though, Marie asks, does this also have something to do with the redistricting decision? I think she's referring to the effort to unseat some of these judges. Micah, could you remind us what happened with the redistricting case?
Sure. So the ACLU and some of our partners, including the League and Loud Light and others, challenged the congressional redistricting plan that came out of the legislature this year, succeeded in district court in Wyandotte County, got a ruling that it was unconstitutional. It then went to the Kansas Supreme Court, which ruled that it was not a violation of the Kansas state constitution. I disagree with that decision, to be very clear, and I particularly disagree with some of the reasoning that they employed in it, which I think will make it very hard for communities of color in particular to have equitable representation into the future. And so I do think there are certainly some folks who are upset at the Kansas Supreme Court about that. What I will also say, however, is that the money that you are seeing or will see in the next couple of weeks coming into the state to defeat members of the Kansas Supreme Court, the folks behind that, They ain't upset about redistricting. They are delighted about the redistricting decision. The big money that you will see mobilizing, trying to get people to fire the Kansas Supreme Court is 100% about abortion and about the right to choose. Various real people in real life may be upset about different things, but the folks who are organizing and mobilizing and raising millions of dollars to try and defeat them, their only interest here is on the abortion issue.
I want to clarify.
Can I jump in on that one?
Sure. If I could just say real quick that I said that question came from Marie. I just want to point out she's the one funneling questions to me. Somebody else asked that question. Go ahead, Judge.
As far as those decisions affecting the vote coming up in terms of who votes for what, redistricting does not affect the selection of judges, in the sense that the Supreme Court and Court of Appeals judges are elected or retained statewide. And so they will, wherever you are in the state, regardless of what congressional district you're in, you have an opportunity to vote on retention of those judges. On the district court, that's done basically county by county, and the redistricting that took place did not affect counties. If you're in Johnson County, regardless of what, if there is mischief in redistricting, it does not affect that. I will note that while the Supreme Court stands for retention every 6 years, the Court of Appeals is and the district courts every 4 years.
With the redistricting, you might have a new legislator or a new congressional race on your ballot in November.
That's true, but not when it comes to the election of judges. Yeah, it's not going to affect that.
We have a question going back to the First Amendment. Do agency rulemaking procedures include public notice and comments? Is anybody prepared to address that? I believe they do, right?
Yeah, and I think Micah sort of touched on that. For the most part, when an agency wants to enact a rule or regulation, yes, there is a public comment period. People can say this is good, this is bad, and then those experts at the agency who've spent their lives probably, getting educated on the issue, then make the decision. But yes, and that's one of the concerns, is that you're taking away the power of the people to comment on rules and regulations. I mean, they'll still be able to comment, but at the end of the day, the legislature can just swoop in with 51% and say, no, we don't like that. So yes, there is a mechanism that these executive agencies, they have to allow the public to weigh in on whether a regulation is good or bad.
There's another question on this topic that says that many of the agencies have regulations that have a sound scientific data review, and they're asking, would the legislative branch then could remove this scientific process? I think the short answer is yes. That's what this amendment would do. Does anybody want to explain or expand on that?
Well, I'm happy to. So at the end of the day, the answer is yes, right? Because the executive agencies can still go through all of their meticulous scientific review, get public notice, comment, pass a regulation, and then 51% of the legislators can say, no, we don't like that regulation. So at the end of the day, it's essentially the executive agencies are still going to go through that process, right? But 51% of our legislators will be able to revoke whatever rule or regulation the agency, probably pretty meticulously, the process or the method to get that regulation or to pass that regulation.
We have a question.
I would just add that is in fact the point, right? Like, not only can they do it, in many respects, that is in fact the point of the amendment. When reality does not conform with the ideological inclinations of folks, they would prefer to have ideology win over the reality and the data. And that is what the amendment allows them to do, because that is the point.
That's right. We we have a question here on the sheriff's amendment asking, can sheriffs be removed for conduct unbecoming, and how do voters remove a sheriff who is overreaching and acting in a questionable manner? I think we touched a little on this earlier, but just to refresh and be a little more succinct, can sheriffs be removed for conduct unbecoming, and how do you do this?
Well, so two ways. The first is by voters, right? And as I had suggested before, if excuse me, if I as a voter believe that my sheriff has exceeded their power, whatever, if I can get enough signatures on a petition, 40% of those who voted in the last sheriff's election, if I can get 40% of my friends and family, right, to sign on to this petition, then I present the petition to my election official and it goes on the ballot. So we voters still would have the power to recall. If 51% of voters believe that a sheriff should be recalled, then the voters have the power to recall the sheriff. So that's what does not change. That is currently how it's done, and the amendment wouldn't change that. The other way that a sheriff can be removed for unbecoming conduct, whatever that might be, currently is the district attorney or the attorney general can start an investigation, and ultimately a judge would decide whether the sheriff should be removed. So what the amendment would do, though, is take that power from the district attorneys completely out of the equation and rest that power to initiate an investigation solely with the attorney general. So those are the two ways that a sheriff can be removed, and the amendment would change that. Initiating an investigation into a sheriff would take that power from the local district attorneys.
So we have a question here that I think is regarding the judicial votes. It says, too often people just vote for who is on the ballot and don't do their research. Are there any ideas on how to get voters to be more knowledgeable?
Let me address that. I spoke to a group similar to this a number of years ago, and after making a presentation, a very nice lady came up to me and said she thanked me for informing her about judicial selection, and she said, you know, it always comes up on the ballot. Should we retain a judge in office? And when I don't know anything about the judge, I just routinely vote no, which set me back as the exact opposite of what I think should be the rational way of dealing with this issue. You have to understand that judges that are on the retention ballot have been gone through a very vigorous vetting process. They've been interviewed in a publicly open meeting, interviewed by a selection committee. They've been vetted by the KBI that does a very extensive background check, and the committee and the governor have all had input from lawyers and citizens and litigants who have had opportunity to be before that applicant, and so if you don't know anything about a judge, I think the basic rule is that they probably should be retained because of this background. I'll tell you that I've been before the commission 3 times, once as a district judge, once as a court for the Court of Appeals, and once applying to the Supreme Court. These are the I can't really see these very well. I have a stack. These are the application forms that I have. You see, well, they're all kind of, take my word for it, they're heavy. There's a lot of stuff here. They know everything about you when the process begins. But now, how do we deal with it now after a judge has been in office for a while? The basic things that you need to look for, and the committee looks for, are your legal reasoning, your integrity, impartiality, how you communicate to the public in your decisions, and what your judicial temperament is. So how do we find out about that? You can read all the opinions that a judge has written, but that'll take you a lifetime. Forget about that. We used to have statewide surveys of lawyers, but that was funded by the legislature, and they pulled a plug on that, and so we no longer have that. But in Johnson County, we have the benefit of a survey conducted of lawyers who have appeared before the judges at all three levels, done by the Johnson County Bar Association. And that survey is available to you if you go to the Johnson County Bar Association website, and you can find out about the judges. Now, the recommendations come from lawyers, but they're lawyers who serve on both sides of cases. It's not just the winning lawyers or the losing lawyers that get to vote. And so you get a cross section of experiences of all kinds of lawyers in Johnson County who have appeared before this judge and make an evaluation. That evaluation covers all of these things I've talked about: legal reasoning, professionalism, all that kind of business. And the survey results that are on the Bar Association website spell out the analysis of each judge on each of those categories, and then summarizes with the recommendation of whether a judge should be retained or not. Let me go through the results just very briefly of that survey. On the Supreme Court, they analyze Supreme Court justices too. The range of votes of lawyers for retaining all the Supreme Court justices range from 71% to 91%. In the Court of Appeals, the judges on the Court of Appeals were recommended that they be retained by a vote of 67% to 100%. Some judges got a rating of 100%. The lowest rating of any judge was 67%. On the Supreme Court, the lowest rating was 71%. Everybody else was above that. On the district court, we've got 12 judges who are up for district judges up for retention. There, the lowest rated judge was 80% to be retained. The highest was 97%. So I think there's a high level of confidence you can make in the fact that the people who see the judges that were on the ground, face to face with the judges, they're the ones who see judges in operation day to day, and quite frankly, they pretty much unanimously, well, in fact, they do unanimously support retention of all the judges on the ballot this year. And I think you can place some level of confidence in that.
We have time for just a couple minutes left for a question or two. Somebody asked which Supreme Court justices voted to uphold personal bodily autonomy. Everybody except for Caleb Stegall is the answer to that. Stegall was the only one who dissented in that case and voted against reproductive health care rights.
Actually, Sherman, just to make sure the record is clear, two of the justices up for retention on the Kansas Supreme Court actually did not have anything to do with the Hodes decision. They were appointed after the fact. So
thank you for that. There are a couple of recent appointees by the governor are up for retention. So if somebody has a chance to maybe look up the names of those who are up for retention who did vote in support, that would be helpful. And while you're doing that, there's somebody who asked about, what's the practical effect, kind of the opposite of this idea of just vote no for everybody if you don't know. What's the effect of just voting yes for everybody? Is that a good idea either?
Well, go ahead, Micah.
I mean, the practical effect is that those folks stay in office for another 6 years until there is another retention for the Supreme Court does, right? For as Judge McAnany pointed out, the other ones are up every 4 years. But for the Supreme Court justices, the effect is that they stay in office for another 6 years, and then folks have the opportunity to vote to retain them or not, unless they retire or meet their retirement age before that. Whether it's a good idea or not, I think really goes back to what the judge was saying about your level of confidence in the judicial process and in your level of confidence in the sort of rule of law and the way the court is doing its job.
And if I might just add, anybody who knows me knows that reproductive rights is like this sword I live and die on. But I think when we're talking about voting judges out, I think we need to just take a step back and say, what's the job of a judge? The job of a judge is to interpret, apply the laws, right? And so if a judge is doing their job, then they should be retained. Now, take any issue, any legal issue, and you will have exceedingly smart minds who differ on the interpretation of that law, legal scholars, professors, lawyers. And so while for me, like knee-jerk reaction, I want to vote the bastards out who voted against reproductive rights. But I also believe in our judicial system and our democracy. And I think that if we are knee-jerk and we vote justices out based on one case and one issue, that's not healthy. That's not healthy for our courts. That's not healthy for our democracy. So I just invite people to think about it, maybe not so much in a knee-jerk fashion, but say, is the judge doing their job? Do I disagree with how their legal interpretation is? Possibly. And there are a few with whom I vehemently disagree, right? But to protect our judiciary and protect our system, we need to think about, okay, is the judge doing their job? Their job is to interpret and apply the law. If they're doing that, even though we disagree, then we should probably vote to retain.
And I would just note, folks, that is why judges are different from legislators, right? So don't apply the same standard to a judge that you do to a legislator or to right with your legislator and your executive branch. If they are doing things that you disagree with, if they are implementing policies that you disagree with and that attack our rights, including bodily autonomy and reproductive freedom, then vote those bastards out.
To leave it. I appreciate everybody for this very informative discussion. Just very quickly, the three justices who voted in favor of bodily autonomy, Daniel Biles, Marla Luckert, and Melissa Standridge. Caleb Stiegel voted against, and Kenyon Wall and Evelyn Wilson are the new judges who are up for retention. Thank you, everybody, to the panelists for joining us.